As the Supreme Court continues to imperil our democracy, there is a bit of good news starting to emerge from the court's conservative majority. It looks like one of the conservative justices appointed by Trump has been moving away from the others and towards the middle. It's something worth watching and makes the next Supreme Court appointment that much more critical. Let's discuss. I'm Dave Aronberg, state attorney for Palm Beach County, aka the Florida lawman, here on the MeidasTouch network. So let's talk about Amy Coney Barrett, the justice who replaced Ruth Bader Ginsburg. When that happened, it was just a devastating moment for all of us who believe in the rule of law, who believe in interpreting the Constitution as a living, breathing document. And it looked like the court was going to sway far to the right to replace the liberal lion of the court with someone who had a reputation of being quite the opposite. And indeed, when it came to Roe versus Wade, the Dobbs opinion, she voted with the other conservatives, 5-4 opinion to overturn Roe versus Wade. Chief Justice Roberts actually voted with the liberals to keep Roe versus Wade, but Justice Barrett went along with the others, even though she testified in her confirmation hearings, along with other conservative justices, that Roe versus Wade was settled law. I'm not giving her a pass on that. I was just as upset as you were, and the Supreme Court unleashed a movement where you have the voters of this country, especially women, continuing to express their dissatisfaction with the court, their disgust. They are motivated to overturn the Supreme Court's decision through legislation, or at least at the local level, because in just about every election since the Dobbs opinion, Democrats have outperformed, and they've outperformed in large part because of the overturning of Roe versus Wade. So this is what's been happening lately, and it's because of the Supreme Court, and that actually gives Democrats the best chance possible in November because of what the Supreme Court unleashed, and Amy Coney Barrett was part of that. But with that said, what we've seen lately is that Justice Barrett has been pulling away from the others. Although Justice Barrett did agree with the other conservatives in granting Donald Trump absolute immunity for things within his core constitutional duties and gave him a presumption of immunity for things in the outer periphery, she still departed from the conservatives when it came to a couple important areas. She sided with Justice Sonia Sotomayor's dissent when she said that she does not join Part 3C, which holds that the Constitution limits the introduction of protected content as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege. She said that the Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. So what she's doing here is saying that there's this one part of the majority opinion that was so crazy, which says that not only does the president get immunity for his core constitutional duties, for example, hiring and firing the attorney general, things within the Department of Justice, he is absolutely immune. So you can't use Trump's conversations with Jeffrey Clark, for example, against him in the upcoming election interference trial in Washington, D.C., which is just nuts because when you're talking about an attempted insurrection, that should not be immune. But the Supreme Court said, no, it doesn't matter what the motive is, doesn't matter what the content is, it just matters that it's within his core constitutional duties to appoint an attorney general. And since the Department of Justice is within the executive branch headed by the president, he's got immunity. And not only that, the court said that any evidence that comes out of those conversations, even if it doesn't pertain to core constitutional duties, that too is immune. You can't use it. You can't even touch it. Or they say in Spinal Tap, don't even look at it. Which Amy Coney Barrett's like, why? Why? For example, Justice Barrett said that what happens if the president is offering pardons for bribes? Well, offering pardons is a constitutional duty, a key one, so you get immunity, but now you can't introduce evidence that you can find that shows that he was selling pardons for bribes because that evidence comes within the Department of Justice, so you can't even use it. You can't subpoena witnesses. You can't collect documents that would show that the person did something illegal. And here's what Justice Barrett said: excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo standing alone could not be a basis for the president's criminal liability. And in a footnote, she also discussed what is a private act versus an official one. You see, the Supreme Court said you still can prosecute a president or former president based on private acts, but the court did not find that there was anything in Jack Smith's indictment in Washington, D.C. that constitutes a private act. They said, well, we're not sure. It needs to go down to Judge Chutkan for a factual finding, evidentiary hearing, which, although that will be a mini trial and that's a way to get the evidence out in front of the public, Justice Barrett agreed with the liberals to say, no, you can try Donald Trump now, at the very least, on the private acts, the ones that are clearly not official acts. You don't have to send it down to Judge Chutkan for an evidentiary hearing. It can be game on right now. And here's her footnote. Sorting private from official conduct sometimes will be difficult, but not always. Take the president's alleged attempt to organize alternative slates of electors. In my view, that conduct is private and therefore not entitled to protection. And she cites Justice Sotomayor's dissent. The Constitution vests power to appoint presidential electors in the states. And while Congress has a limited role in that process, the president has none. In short, a president has no legal authority and thus no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. So, a ray of hope. You have Justice Barrett saying, I'm not going along with this. You should put Donald Trump on trial for these private acts right now. And even though I think she had it wrong when she agreed with the majority in their overbroad opinion, the worst part of the opinion in my mind was that section that says that even the evidence that you could collect about bribery and other things that are not official acts, that's forbidden. She didn't tolerate that. She went with the liberals on that. But that's not the only crack in the armor here. That's not the only display that Justice Barrett is breaking away from the MAGA justices. According to Newsweek, in recent months, Barrett has had open spats with Justice Clarence Thomas, the court's most conservative member, even interrupting Thomas's pro-gun lobby questions during oral arguments in United States versus Rahimi to read from a barring order Rahimi's former girlfriend had obtained from a Texas court, which detailed his violence towards her. Remember, Justice Thomas was the sole vote to say that even if you are a perpetrator of domestic violence and you're under a restraining order, you still should have access to a gun. It was 8-1. And not only did Justice Barrett disagree with Justice Thomas, but she even interrupted him during oral arguments and made a point to show how wrong he was. And that's not all. On June 26, Barrett and two other conservative justices sided with President Joe Biden's administration in a dispute with Republican-led states about social media in a 6-3 ruling on Murphy versus Missouri, in which Barrett wrote the opinion. The Supreme Court said Republican states and individual conservative plaintiffs don't have standing to sue administration officials over social media platforms' content moderation decisions regarding COVID-19 misinformation. Justice Samuel Alito, yeah, that's the guy with the upside-down American flag, wrote a dissenting opinion in which he was joined by Thomas and Justice Neil Gorsuch. Louisiana, Missouri, and other parties in the case had argued that the Biden administration had tried to prevent conservative views from being seen on social media. In her decision for the majority, Barrett wrote that the plaintiffs had neither the right nor the legal standing to sue. You see, the conservatives around the country still maintain that, oh, this is wrong, that the government should be telling the social media companies what to publish. But that's not what happened. Because of COVID misinformation, because of Russian misinformation about a lot of subjects, the U.S. government had reached out to social media companies to let them know that some of this stuff was misinformation. They didn't pressure them. They didn't intimidate them. They just provided information, just like anyone else can do. And right-wingers said, no, you can't do that. Yeah, yes, you can. Yes, you can. And Justice Barrett wrote the majority opinion to say that you could. So this is a trend that could continue, especially when you look to Chief Justice Roberts' majority opinion in the immunity case, where he chastised the liberal justices and Justice Barrett for essentially being hysterical in terms that at least one observer found to be quite sexist. And if you go ahead and you start going after these women justices as being just out of their minds, I have a feeling that it could prompt those women justices to fight back and to start flexing their muscle together. This is something that we should keep an eye on. It's not the first time that a Republican president has appointed justices that they think are going to be more conservative than they are. Some of them turn out to be liberals. I mean, Dwight Eisenhower appointed 2 justices to the Supreme Court, Earl Warren and William Brennan. Well, Brennan became one of the most liberal justices in maybe history, and Earl Warren became the most liberal Chief Justice in history. In fact, Eisenhower famously had a quote about that saying, "I made 2 mistakes, and both of them are sitting on the Supreme Court." And he was not alone. It was Richard Nixon who appointed Harry Blackmun to the Supreme Court. Yes, that Harry Blackmun, who wrote the majority opinion in Roe versus Wade. You also had David Souter, one of the liberal justices in modern times, who was appointed by George Herbert Walker Bush. And Souter got appointed because President Bush was advised by his chief of staff, John Sununu, that this guy back in New Hampshire named David Souter did not have a paper trail, but was reliably conservative, and he would get through a bruising Senate confirmation. So he got appointed. I remember at the time when he was appointed, he was a mystery man, and we thought he was going to be some real right-winger, and he turned out to be one of the most liberal justices in recent memory. This is what has happened over time. Will it happen with Amy Coney Barrett? Probably not a liberal justice, but someone who seems to be creeping towards the middle. And the more she gets provoked by Chief Justice Roberts, I think that trend will continue. In a piece entitled, "Don't Be Hysterical, Ladies, Daddy Chief Justice Knows Best," the great Dahlia Lithwick from Slate remarked about the Chief Justice's condescending tone towards the dissenters. Lithwick says that it is nevertheless pretty jarring to hear that kind of condescension trotted out by Chief Justice John Roberts in the democracy-altering immunity decision handed down Monday. The court granted itself the imperial authority to confer upon the president powers of a king. But although Justices Sonia Sotomayor and Ketanji Brown Jackson said as much in their respective dissents, it fell to Big Daddy Chief Justice Roberts to intone to his readers that their aggregated dissents strike a tone of chilling doom that is wholly disproportionate to what the court actually does today, implying that the dissenters were overreacting and without ever attempting to address the substance of their claims. Roberts accused them of fear-mongering on the basis of extreme hypotheticals about a future where the president feels empowered to violate federal criminal law. Our dissenting colleagues exude an impressive infallibility, writes Roberts, like a girls' soccer coach. While their confidence may be inspiring, the court adheres to time-tested practices, instead deciding what is required to dispose of the case. Hate the player, change the game. So that's the latest with the Supreme Court and our democracy. Midas Mighty, keep the faith. Let's keep hope alive, and let's make sure we know that the next election is the most important of our lifetimes, because the Supreme Court is at stake. Clarence Thomas wants to retire, and he's going to likely retire in the next 4 years, and you want his replacement to be someone who actually believes in the rule of law rather than tries to establish something else. So that's the latest. I'm Dave Aronberg, aka the Florida Lawman, here on the MeidasTouch Network. If you like this video, please like it, subscribe, and leave a message below. I love seeing your comments. Also, check out our sister channel, True Crime MTN, where we talk about true crime cases that don't make it onto the MeidasTouch network, but are still really interesting, and we'll be following the Alec Baldwin trial pretty soon. So please give us a follow, and I'll see you next time.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.